Welcome to This Week in Immigration. This is our weekly podcast on U.S. immigration law. We generally provide information about what's happened over the last few weeks, some updates, and of course some opinions. If you like the content, we'd love to have you subscribe, hit the like button, and just help out that YouTube algorithm. All right, today we've got a lot of things going on, so we're just going to hit them up. We'll put our topics in the description down below. If you want to just click that, you can see what we're talking about today. But let's dive right into the variety of stuff that's happened over the last week or two. So number one is there was a court hearing about asylum EADs. Okay, now let me give you some background on that. When you apply for asylum, you're eligible for a work permit, an EAD, generally after a specific period of time called the clock, meaning there's a 6-month or a 1-year waiting period. And what's happened is there have been massive delays on the asylum front, and there was a big lawsuit. In the lawsuit that they filed, they essentially said the delays are keeping people from functioning and forcing them to work illegally in the United States. And what ended up happening is the court rejected all those arguments, and we're at a place right now. We don't have a final decision in that lawsuit, but we do know that the renewals for asylum seekers has not been sped up. It's not been expedited in any way. And in fact, those individuals are falling into this giant pool of individuals stuck in the employment authorization line, and they are getting no relief. And I think the thing that's so important I want to bring out today is that, the Biden administration has the power to fix this. The Biden administration can go in and do things like make extensions or specifically note that asylum seekers who are in the process or maybe have had an interview or are waiting for an interview, they can qualify for automatic extensions like they've done with other categories. So right off the top of the bat here, the court case we heard arguments last week. We watched closely what happened, but it looks like the court's going to end up saying that this delay can be fixed by the president or Congress, but not by the court. We'll update you when we know more. In other news, USCIS just reiterated or clarified a policy, which is really, really helpful. Essentially, this policy is that E2 spouses and L1 spouses are eligible to work without an EAD. Now, I knew this in regards to the E2 spouses because there's a court case many years ago, a BIA decision that specifically said an E2 spouse does not need a work permit to work within the E2 business and can do so, whenever they like. What USCIS has done is provided E and L spouses with employment authorized simply incident to status. Okay, so very important. If you are the spouse of an E visa or an L visa, based on that alone, you are eligible to work in the United States. The problem is going to be that there's no Form I-9 yet. The I-9 is the authorization form that employers use to make sure that you're working legally. That form has not been updated, and USCIS is going to update that form. So while incident to status permission to work is great, you might have some bumps in the road getting your employer to get that done. All right, in other news, we have some very important developments in regards to frontline healthcare workers. USCIS has said they're going to allow EAD work permits to be expedited for nurses who are applying for renewals to continue working in the healthcare industry. And this is something that Trump kind of noted a couple years ago, and we never saw anything follow up. He just sort of said it. We want to have expedited process for healthcare workers or frontline workers in the pandemic, and then nothing else happened. In that there was really no process. USCIS has made it very formal that if you are working in the healthcare field, they will look to expedite those cases. Now, expediting, in case you don't know, involves putting in a phone call or putting in a process online, then following up and following up. So I don't really have a lot of hope this is going to be smooth, but it is good news. And if you are in the healthcare field and looking at your EAD expiring or filing a new one or have filed one, you should try to get it expedited through your attorney. And a point I want to make right now about EADs, really, really important, is that this administration has really dropped the ball. You have this backlog with EADs that came about during the Trump administration because of a biometrics requirement. H-4 EADs are waiting 12 months, 13 months, even more. I've seen student OPT waiting for their EAD, 6 months, 8 months, 12 months. And what the administration has done is simply allow for a 6-month extension on renewals. They've said, if you're renewing your EAD and you file your EAD on time, well, we'll give you an additional 6 months automatically to continue working at your job while your EAD is pending. And here's the part that makes 0 sense. It takes 13 months for an EAD application to get approved. So they'll give you 6 months if you file it on time, but you're still waiting another 6 to 7 months with what? With nothing? I mean, this makes absolutely no sense. It's nonsense. And to see these things exist and go on and on and on is really, it just makes no sense. And clients, legitimate people, employers, they want the EAD approval. They want these things clarified so they can continue to employ people. But at this point, as of today, this administration has done nothing. We have these fixes I've announced to you, but why would you come up with a plan that gives 6 months when the processing time is 12 months? It makes no sense. So for right now, the Biden administration has really dropped the ball on this, and the EAD, just the whole world of EADs or work permits, is a complete and total mess. I'd like to see some changes. We follow it very closely, and if we find something new, we'll report it or post it on TikTok. Keep following us. Okay, so USCIS did announce that they're going to expand STEM program acceptance for the STEM OPT. This is really big news. This is the kind of development I'd like to see. Basically, STEM, science, technology, engineering, and mathematics, is a field that has been set by USCIS within the SEVIS system to apply to a very specific and limited number of degrees. They announced that they have expanded their STEM program to include 22 new different degrees. And that is great news. 22 new fields is going to open the door for many people. And some of these are very, very simple, like mathematical economics or data science or general data analytics or quantitative methods. I have seen people that have degrees that are just right in the zone. They'll do something like, for example, quantitative methods, and they'll go straight into the tech industry because they're doing statistical analysis. It's really, really important for different kinds of apps and different kind of business solutions. But those individuals did not qualify for STEM OPT. Remember, STEM OPT is an additional time, additional 2.5 years over your original OPT. So that additional 2 years is a big deal. And we want to see that program grow, we want to see that program expand, and we see that now. So feather in the cap to the Biden administration. This is the big move. This policy change is going to change things a lot. Check out our notes. We'll give you a link so you guys can see which new fields are open to STEM OPT. I will note that this is also a missed opportunity. There are many fields that could be added to the STEM program, and basically the one that comes to mind right away is nursing and nurse practitioners, okay, which is the master's degree within the nursing field. They could have done that and added nursing to the STEM fields where bachelor degree RNs would then get the STEM OPT and be able to work a lot longer out there in the field, helping with things like we have right now in the pandemic. So the missing out on nurses is a kind of a big kind of blow, and that's something the Biden administration really dropped the ball on. Recently, we saw a lot of news about world #1 tennis player Yokovich. Now, Yokovich was going to Australia to play in the Australian Open and defend his win from last year. Yokovich was stopped. It was very big news and was not permitted to enter. Now, I actually have to agree with what I see in this story. Essentially, Yokovich said that he's not vaccinated and he's had COVID twice and 2 different times, and that he's not going to get vaccinated. There was some issue about some sort of fake story, maybe he had said he was vaccinated or had some documentation that he was vaccinated, but he admitted that he's not vaccinated. And Australia being an island nation and also a very strong COVID pandemic policy, basically deported him. They put him into lockdown, which you see for individuals who are not allowed to enter, which is usually a hotel of some sort where they're doing a quarantine. And then from that quarantine, they did a whole case, and they did an appeal, and the judges on the high end even said he's going to have to go. So, I mean, some of this is a little bit scary for my clients if that happens, but it's good to just know what the policy is and not believe you're going to be an exception to the policy. And I hate to say that to Mr. Yokovich because he's the world #1 tennis player. If anybody should be given exceptional treatment, it's him when it comes to sort of participating in his sport. But this is just going to show that it looks like, Australia has said the pandemic matters, and our policies of the pandemic matter, and you should have known that before you came. And that is something where I point that out to my clients, and we deal with them all the time, coming in and out of Europe, coming in and out of Asia. Policy does matter, and how this work really, really does matter. And because of that, we need to put a little bit of blame where it lies with Mr. Yokovich and his team. They should have known they were going to have trouble, and they should have tried to do something before he entered Australia without a vaccination. In other developments, USCIS announced that they have upgraded the online policy manual for the O1 visa as well as the national interest waiver. So we get these announcements, we check them out, and basically we're looking for what is the detail, what's the added value, what can we present, what can I learn from this? And I'll be honest with you, I can't figure out what they're talking about. They've upgraded it, and it may be something small, or maybe just a simple tone, or it may be something like they're going to be more open about certain things. But from what I've seen, they're just trying to evaluate individuals of extraordinary ability with certain kinds of new words. They're talking about skill sets, knowledge, or expertise that might be shared across different fields of study. Not sure what that means, but we've got a lot of O1 cases pending, so we'll update you with what we find out through our own experience. Last bit of news today is that we saw some postings and some news about the employment-based cap, and whether USCIS announcing whether there's more available in EB1 and EB2 versus EB3. And the truth is, let's be very, very honest. Counting of numbers and the visa bulletin, it's a bit of a mess, right? Everybody tries to judge when their case is going to be current. People are always looking at when the visa bulletin might shift or how they might benefit by being in a different category. I can't tell you what USCIS meant to say or do by telling us that EB1 is faster than EB2 or EB3. But at this point, we know that in specific countries, that backlog and that cap has not moved and makes no sense. In the general other world, EB1 and EB2 are wide open. I'm not sure that really makes a difference. If you're in the other world category, rest of the world category, and you have an EB1 case or an EB2 case, we already know that. So some of the stuff I saw online over the last week or so about the EB cap, there's a lot of discussions on Twitter about that. Guys that I follow were very prominent. It didn't make a lot of sense in that. There's nothing major that's changed, specifically in India and China. In the rest of the world, we know EB1 and EB2 have been open and are still open, and those categories still work the way they have always worked. All right, so we do have a couple of questions here, and I'll give you maybe an immigration story as well. I've got a question here. I was abused in December 2017. I never called the police or did a police report, and I was just subject to a lot of trauma. Can I do something now? Because this might be a U visa. Is it too late? So in response to your question about the 2017 December abuse, you're going to have to call the police and figure out if you can file a claim on that. There is a statute of limitations. There is sort of credibility. There's a lot of issues that come up. I've relayed to you guys before that I had a client that was, well, maybe I haven't, so I'll tell you a story. I had a client that was raped by her attorney. And she came to me many years later and told me this story, and it was very sad. And I obviously, I brought in a female staff member, and we sat and we all talked about it, and she told me some details. And essentially, she was ashamed and embarrassed and didn't know what to do after this event. So, I always try to help people out. So I did get her in touch with the law enforcement, and she did an interview. And eventually, the police officer called me, and we sat and talked together on the phone. The police officer with her and I, and he said, "Look, I believe her claim." He was really candid and clear. I believe it because I've seen these things happen, and I really do believe this happened to her. We just going to have a problem, like investigating this, maybe getting credibility. We can't get a rape kit. He pointed out we can't get any physical evidence, which we normally do. But he was there to stand up and help her. So what I would say to this person, in my experience, it's worth it to call the police. You call the police, you make your claim, and you see where it goes. If you just didn't have the guts or the fortitude to stand up because you were a victim of a crime, I understand that. Go ahead and stand up and try it now and see what happens. And if you need an attorney to help you out, give us a call. We can always get on the phone with you and try and be there for you. All right? All right, I got another question here. E2 visa versus EB5, which is better for Indian citizens coming to the USA? Well, that's a really easy answer, okay? Which is better is the EB5. And that's because there is no E2 Treaty of Commerce between the United States and India. Believe it or not, world's biggest democracy, India, huge economy. You would think that the United States would have what's called a Treaty of Commerce, but we do not. The United States E2 visas are dependent on what's called, again, a Treaty of Commerce between the United States and those countries. We have about 70, 75 countries that have those, including Iran. And the Iranian treaty goes back to 1950, where the U.S. had a treaty with the Shah of Iran, and it's lasted all the way until, well, Trump got rid of it in 2017. But before that, we had E2 visas for Iranians. Indian nationals with an Indian passport cannot get an E2 visa. I do have Indian nationals that relocate and get new passports, UK, Canada, and when they do, we do an E2 visa for them using that new passport, okay? So for now, EB5 only. All right, we got another question here. It's from Cindy88. My husband's dad passed away, but he's a citizen. Last time he saw his dad, he was 16. Here's a child born out of wedlock. How can he get proof? Okay, so Cindy, that's a really, really tough question. What you're really basically saying is, is my husband an automatic citizen of because his father was a citizen? Two key things is the date. The other thing was born out of wedlock. Born out of wedlock is what's called, we have to do something. I'm hitting a blank. There's a process that's very specific for children born out of wedlock, specifically from a father. The father has to legitimate the child. That's the word. They have to legitimate the child, okay? And the legitimation process is different for every country. So, for example, in Mexico, they have to, there's a certificate they can do, and they have to actually support the child, right? Hold the child out as theirs. So, for example, if the father was on the birth certificate and it was in Mexico, and then they did something to support the child during their lifetime, then they could be legitimated. That's just the first step. After legitimation comes other processes. In your case, the fact that your dad, your husband's father passed away may wipe him away from any relief. He may not be able to use that for his benefit. But you should talk to a lawyer, go through the process, get the documents, see if you can actually do something. But it becomes more difficult for cases that were filed before 2000 or existed before 2000 because the Child Citizenship Act changed the face of derived citizenship in that you can have one parent deriving citizenship for a child, whereas before that it was always about the relationship, natural born mother, married to father or not, and then legitimation and several other things. Right now, I would tell you my quick answer on what you've told me. It's a possible, no, it's going to be tough for you. But, it's always worth looking into. You never know what you're going to find. You never know if he had filed a case for his son in the past. That might help, and that might be really, really good for you. Okay? So do that. Maybe talk to a lawyer, get a case, give us a call. We'll try and help you out. Okay? All right, that's it for this week. We really appreciate you guys checking us out. We do tons of immigration content. We help people from all over the world. I get calls every single day from you guys, and I really appreciate that. A lot of you guys have complicated cases that you want us to hire us to help you out. Others have straightforward cases, and we help you guys out as well. What I want to put out there is, we have a long-standing reputation. We have done well by our clients for many, many years. Check out our website. Check out our client reviews and testimonials. Set up an appointment. We can chat if you have any questions. Stay safe out there. Bye.